So I'll start by introducing myself. My name is Joanie Bouchat. I am the interim Chief Regulatory Officer for the college, so I oversee the 3 regulatory program. I am very pleased to be here with you today and host this webinar on standard and regulation changes. This was a need that we identified through our HPOA webinar series as a good follow-up engagement opportunity. We have set up these webinar with specific profession grouping based on the degree of changes that happen between the legacy standards that you had in your profession and what we now have as of April 1st. The webinar are open to any of the profession we regulate, though, so there might be in attendance today other people than psychologists. With that said, the focus of the presentation today are some changes and questions that we have received from the psychology profession. If you can move the slide, please. I will start the meeting in a good way by acknowledging that the offices of the College of Health and Care Professional are located on the ancestral and unceded territory of the Coast Salish people. Our Vancouver office specifically are located on the Musqueam, Squamish, and Tsleil-Waututh nations lands, and our Victoria office are located on the Lekwungen people lands. We're conscious of the privilege we hold that allows us to carry this very important work that we do in regulation. We're the first people have maintained special relationship with the lands and water for thousands of years, and where their relationship continues today. Thank you. So today I have 2 guest speakers with me. We have Tiger Sun Young, who is a psychologist and a practice advisor at the college. Dr. Tiger Sun Young will do a quick presentation based on the themes that we have heard from you since April 1st. And then we will also take question. We have had pre-submitted question, and we will also do our best to address as many questions as we can that will come live in the Q&A box that you have available in the Zoom webinar. The other person that is with me today to answer a question is Susan Paul, who is a regulatory transformation advisor at the college with a focus on quality practice. Susan led the development of the harmonized ethics and practice standard, and I've also done the heavy lifting work of mapping and doing a concordance exercise with all of the legacy standards and making sure that we would be able to connect those former documents to our new documents. In terms of format, as I've said, we'll take some questions at the end. We'll also make sure to draw on the question that we have received in advance. I'll just note that we are really focusing our question today on topics that relates to standard and regulation changes. We have seen that we have received lots of questions on other topics that relates to the regulation of psychology. We will probably not address these today, but we will be using them to assess other engagement opportunity. This webinar series is kind of like a first since the HPOA series. We are seeing great interest and engagement, and so I think we are already thinking of other opportunities of engagement we might do probably in the fall as we're getting close to summer now. But so just to say that question that you have submitted that do not relate to today's topic might not be addressed today, but we will definitely use them either to inform future communication or to plan future engagement. And on the next slide, I believe, I wanted to remind everyone, so the HPOA webinar series that we hosted between December 2025 and April 2026 covered a lot of topics with regard to the transition to this new legislation, and in the themes of question that we receive, a lot of them were covered in these webinars. So we wanted to remind people, because you may have not been able to attend these webinars, and we have kept the recording and they're available on our website. If you go under the tab of legislation and bylaw, you will find a tab that's specific to HPOA, and then there will be a section that's on our webinar. And we hosted webinar on governance and bylaw, on licensure, delegation, on anti-discrimination, on public protection, which is the whole complaints process, ethics and practice standard, and the last one was on restricted activity and certified practice. Okay, I think that's it for my intro. So why we are offering these sessions? I've mentioned that we have seen from our webinar in March that the changes to the harmonized ethics practice and standard were generating lots of questions. So we're hoping that today's webinar is really a first step to support you in understanding and applying those new ethics and practice standards, and also continue to further your understanding of the new regulatory framework, which include restricted activities and the other regulation under the HPOA. And so what to expect, I think I've covered that. We do want to make sure we have an opportunity for a Q&A. Tigerson will speak to the common question that we have heard for your profession since April 1st. We'll try to clarify some expectation in terms of the new standards, and then support some consistent understanding, which is an important goal for us as we continue to move forward under this new legislation. So I think, Tigerson, I will end it off to you.
All right. Thank you, Joannie. It is great to see you all. Even though I cannot see your faces, I can see a lot of your names and a lot of very familiar, names here today. So I'm delighted to see you again. And for those who I have not met in the past, I look forward to getting to know you. So thank you again for taking your time to attend this webinar today. So like Joannie said, we obviously will not have the time to address everything. So my main agenda today is very simple. We're going to focus on just a few things. There are likely bigger topics related to the practice of psychology and school psychology following the inceptions of the HPOA. Now, a disclaimer first, these are my understanding and do not necessarily represent the official positions of the college. So I trust that both Susan and Joannie will jump in if I am totally off target over here. It goes without saying, no legal advice is given here today, and the information is current only as of today, June 9th, 2026. So things may change down the road when regulations change. So with that introduction, let's start with the very basic first. Especially in the beginning phase following the inception of the HPOA, one of the most common questions that I have received is where to find the regulations of psychology and school psychology practice. Now, anyone still remember this little blue book here? Very nostalgic, right? So in the past, one of the first places that we often look to, for those regulatory guidance is likely the Legacy Code of Conduct. So as of April 1st, 2026, the Code of Conduct is retired. So the college ethics and practice standards is now in force. So what it means is very simple. The Legacy Code of Conduct is no longer enforceable. Now, of course, it doesn't mean that the legacy code is useless. The legacy code can still give us some customary and historical informations that we may need to help us understand the current standards. But now that the legacy code has retired, so one of the first places to look for the current regulatory guidance is likely the ethics and practice standards, like what we have often done in the past. Now, as you may have noticed, and many of you have shared this thought with me before, many licensees may find the current standards less prescriptive in some areas, at least. And this is intentionally done so that the standards can balance between the professional expectation and room for informed professional clinical judgment. Now, in the event that you really miss some of the prescriptive approach, though, do not panic. There are ways to do that too. Let's go to the next slide, please. So if we go to the HPOA, there are actually still a number of prescribed duties for licensees, including psychology and school psychology licensees that we need to follow, such as the ones here that we see in Division 5. So we can still get a little bit of our fix from there if we need that. So kidding aside, though, not only do we have the practice standards as our first stop, we now also have the HPOA that can help us learn more about our professional responsibilities. Now, it is likely a little daunting to read the HPOA. I mean, after all, it has 10 times more clauses than the Retired Health Professions Act. But what happens here is that the HPOA helps clarify many of the issues that were a little less clear in the retired HPA. Next slide, please. Now, in addition to the HPOA and the practice standards, many of us are familiar with the psychologist regulations in the past. Now, after the HPOA is in full force, on April 1st, the psychologist regulations has also been repealed and is no longer in force. So instead, now we have the Health and Care Professionals Regulation. Next slide, please. The good news is, just like the former, psychologist regulations, the current Health and Care Professional Regulations also outlines the scope of psychology and school psychology practice, along with the restricted activities that psychologists and school psychologists can perform. Just like the former regulation, the current Health and Care Professionals Regulation allows psychologists and school psychologists to provide a number of psychological health services that we see here in Section 54. Yes, the wording may be slightly different, as some of you have mentioned to me, but the daily practice of psychology and school psychology should not have any major changes because of those changes. If an activity is customarily, traditionally being treated as a psychology or school psychology activity, such as psychological testing, psychotherapy, they are likely remain to be so under the current Health and Care Professionals Regulations, unless otherwise indicated by the college. Diagnosing mental disorders remains to be the only restricted activity that psychologists and school psychologists may perform, as seen here in Section 56. Next slide, please. Now, if this is still somehow not enough for you, well, congratulations. The good news is now we have 2 more regulations available these days, including the Regulated Health Practitioners Regulations and the Health Professions and Occupations Regulations. So if you have not had a chance to read through these current regulatory instruments, it is likely a good place to start for practice guidance. And all this is available on the college webpage. So after we reach the main college webpage, like Joanne mentioned earlier, click on the legislations, bylaws, and standards tab. Then you will see all those regulatory policies, instruments right there. So now that we have looked at where to find some of this regulatory guidance, let's switch gear a little bit. Next slide, please. One of the major areas that has been asked is likely record retention. Many of you have asked me, okay, why it needs to be 16 years when the legacy code only required 7. What's the rationale? What's the reason, right? Okay. Now, before we get to that question, though, let me ask you another question. And Joanne is going to give you $5 if you know the answer. Okay, just kidding. All right. Have you ever wondered why the legacy code used 7 years? Right? I mean, that's kind of an odd number, isn't it? Why not 5? Why not 10? Why 7? What do you think? Right? Think about it. Why did the legacy code use 7 years as a benchmark? All right. Well, let's go to the next slide, please. Well, it turns out this has something to do with another statute. It's called the Limitation Act. The current Limitation Act came into force June 1st, 2013, 13 years ago. So for those who are not familiar with this act, so this is an act that provides the set period of time that people have to start a legal proceeding in most civil matters in BC before they are completely barred from filing the claims. Let me ask you another question. Before 2013, before this current Limitations Act came into force, take a wild guess. How long could people wait to file most civil claims before they will be completely barred from filing the claims? Anyone knows about that? So this is also known as the ultimate limitation period. 3, 2, 1. If you guessed 30 years, you got it. All right. So way back then, people could wait 30 years before they filed a civil claims. Okay. That's a long time, isn't it? All right. Now, let me ask you another question. Joanne is going to give you $10 now if you know these questions. All right. How long could people wait to file a civil claim against a medical professional, including psychologists, before this Limitations Act came into force in 2013? Now, I did not include school psychologists in these questions because school psychologists back then were not included in the health regulated profession yet. So in other words, it would take 30 years to bar a civil actions against school psychologists back then. But other medical professionals have a different standard, have a different limitations period. Back then, you know what? The limitations period for medical professions, 6 years. Okay. So the current Limitations Act in 2013 changed all of that. 30 years, that's way too long for people to wait, right? Can you imagine? Wait until 29 years later to sue us. Okay, that's a long time to wait for, right? And on the other hand, people are complaining, oh, okay, why medical professionals could get away with only 6 years? So the Limitations Act take the middle path, 15 years. Okay, do we start to see the pattern now? So back then, 6 years Limitations Act, okay, for the medical professionals, that's why we plus 1, 7 years. 15 years plus 1, we got 16 years. This is how we come to that number, isn't it? So the legacy code, okay, was revised in 2014 to reflect this change as well. Can we switch back to the last slide really quickly? So in 2014, thank you. Yeah, the legacy code actually revised all this along with all these other updates. Now, if we read the legacy code more closely, 7 years were not the maximum. It was the minimum. The revised legacy code in 2014 says not less than, you see the highlighted part over here, right? So it was not wrong, but it is obviously, okay, understandably, it could be more clear to reflect the changes in the 2013 Limitations Act. So that's why in the new, okay, practice standards now, It helps makes it even more explicitly clear and make it more uniform with all these other health professionals, colleges and all that to reflect 16 years. All right. So far, so good, right? Now, some of you asked about this too. Well, if the records were under the legacy code, would they still fall under that old rule instead of this new 16 years requirements? Now, remember, this 16 years requirement is actually not new. It has been like this for the past 13 years, since 2013. So to put it this way, if the records have not been properly disposed of and are still under the 2013 ultimate limitations period, then yes, they are under the current rule of 16 years, right? So the current standards just make this expectation more explicit and consistent, not exactly changing or requiring anything new. Now, on a side note, even 16 years, if you look at the left side, okay, of the slide over here, if you read the practice standards closely, as seen here in section 6 in the records chapter, it says at least, not at most. So this is just the minimum, not the maximum either, right? Why? Well, because some cases are not subject to this ultimate limitation period. Things like child abuse, sexual abuse, or even some disability cases, they do not have those limitations period at all. So we as psychologists and school psychologists likely deal with those issues on a pretty regular basis, isn't it? So to determine how long a record needs to be kept, then it really depends on the issues in the record. For example, if you work with children, especially children that have been abused, then your records may need to be kept for much longer than even 16 years. So a lot of those details are also available in the college, newsletter. Next slide, please. Oh, one more, please. Thank you. So with this understanding, so many of you have expressed an interest in digitizing our records. Given the length of the record retention requirements, it makes sense, right, to digitize our clinical records. And so psychology and school psychology are likely one of the few health and care professionals that still use paper files. Reasonably so, because a lot of our tools, like the psychological test, are still paper and pencil based, as opposed to digital, isn't it? So this begs the question, if we are able to digitize not only just our clinical notes, but also these testing protocols. Now remember, psychological testing is more than just a regulatory matter. Psychological testing also involve other statutory and contractual requirements, such as copyright law, contract law. So the answer to that question is that, well, it depends. All right. Next slide, please. So I've talked to several major test publishers, and they suggest that, yes, digitizations may be permissible, but under some conditions, and the requirements vary by publishers and the products. So most, if not all of them, say we can only digitize completed test protocols. So not blank ones, in other words, okay? And they all require some kind of access restrictions to those protocols by non-psychologists and non-school psychologists after they have been digitized. So this makes it a bit tricky if we work in like a multidisciplinary setting. So some arrangement has to be made, with those organizations. And some test publishers like Pearson, they also require a prior request from the test publishers before digitizing their copyrighted test protocols. So be sure to check with those test publishers first before you digitize any of those copyrighted testing protocols. From the practice standards perspective, there's no prohibitions to digitize our records unless prohibited by law or other contractual requirements. All right, next slide, please. Last but not least, before we jump to the Q&A segment, another popular question is about retirement. So first of all, the requirement of having a designated professional executor is no longer required by the college. It doesn't mean that we cannot have a professional executor. Next slide, please. And in fact, it is one of our professional duties to think of a succession plan, as indicated here in section 7.2 in the records chapter of the practice standards. It may still be a good idea to have a professional executor set up, depending on our specific circumstances. Now, in the event that we become ill or incapacitated for some reason, a professional executor can step in to manage not only our clinical records, but any other matters designated in the executorship. But this is no longer a requirement at this point. Now, what it also means is that former licensees, so folks who choose not to renew their license any longer for whatever reasons, like retirement, may now be able to hold on to their own records instead of looking for a professional executor or another psychology licensee with an active license to hold on to their records, as indicated here in section 7.3. Now, for those who work in an institutional setting, like hospitals, school districts, probably nothing has changed. Your employer or your organizations likely are the custodians of these clinical records, and they will continue to have the legal duty to keep those records securely and to manage who can have access to those records. And for those who retain independent contractors now, so this means that a clear clause respecting the ownership and custodianship of these clinical records should be a part of your contractual agreement with your contractors. I've seen a number of questions raised when an independent contractor no longer continues the service, and now the ownership and custodianship of those clinical records become an issue of contention. So these issues are almost always better clarified right at the outset of a contractual relationship. Now, it goes without saying, the college should be notified of any changes to the location of our clinical records within 30 business days, as indicated here in section 7.6. In the event that a patient of yours needs to get hold of their records and they cannot find you, then the college will have those information available to your patients. I think there are also some questions related to the professional liability insurance and record retention, especially if we are to retire soon. Now remember, these two are separate issues. Whether we have the records or not, we can still be sued by our patients or others for our professional activities, isn't it? The professional liability insurance is to cover our professional activity, not our records. So whether the record retention is 2 years, 5 years, 30 years, right, or forever, it does not matter. It does not tie directly with the professional liability insurance. It is not like that I can tell the suing party, oh, sorry, I don't have your records, and therefore you cannot sue me. It doesn't work that way, right? So those are separate issues. Now, one final thought. We have talked about where to find regulatory guidance, but knowing where to look for those guidance is only part of the questions. The other questions many people are asking is, So, what does it actually mean when standards rely more on professional judgment? Professional judgment does not mean just doing whatever we feel good, right? It means making decisions intentionally using multiple sources of information. If you think about it, this process is something that we as psychologists and school psychologists are familiar with. We do this every single day, right? Evidence informed decision making by using a multi trait and multi method approach. So, professional judgment equals standards plus evidence plus context plus clinical reasoning plus documentation. And when these pieces come together, our decisions become easier to explain, not only to ourselves, but also to patients, to families, to employers, and to the college, if necessary. Increasingly, regulatory scrutiny is only less about whether our decision was perfect, but more about whether our reasoning process was thoughtful, evidence informed, and documented. So, professional judgment without documentation can become difficult to demonstrate later. And this is also one of the reasons why record keeping becomes even more important these days. Not simply because the records must be retained longer, but because they document the professional reasoning behind our decisions. So I hope today's presentations has helped raise some of the awareness of these issues and topics, where to find the current psychology regulatory information, record retention and digitizing our records. Professional executorships is no longer required, but it is not prohibited. Professional liability insurance and record retentions are two separate issues, and how professional judgment can be formulated under the current regulatory framework. Understandably, we only have very limited time today, so we're not going to discuss everything. Many of you have already utilized the practice support service, and if you have not, we at the practice support are here to help. Having said this, though, please do know that we are unable to provide advice to your specific circumstances. We can only give you general regulatory information. So if you're concerned about your liability for a particular matter, then what you should do is to consider obtaining an independent legal advice about your specific circumstances, which is typically available through our professional liability insurance coverage. So, on that note, thank you for letting me share my thoughts with you today. Really appreciate your time. So, I will now turn the time back to Susan and Joanne.
Thank you, Tigerson. I see we have lots of questions that have started appearing in the chat, and we also have our pre-submitted questions. So before I turn it over to Anita, who will moderate our question, can I just go back to the slide, please, for a second? I see the slide have disappeared from people's view. Wanted to mention that tomorrow we also do have another webinar available to all licensee of the college. The webinar is our speaker is Elaine Alecht, and the topic of the webinar is on cultivating safe spaces, so self-care, belonging, and human capacity. For those of you who do not know Elaine Alecht, she is a fabulous and amazing speaker. She has been working in the field of cultural safety and humility and anti-racism for a really long time, and we're really excited to be able to feature her into a webinar. So if you have the chance to attend, it is tomorrow. If you have not registered, registration is required. You'll be able to find it through our newsletter. So You guys can go back to show our regular faces if you want. Anita, I don't know if you want to start with some pre-submitted question. I'll let you handle that. I know Susan has already flagged a couple of questions she wants to answer live from the chat. So yeah, we're ready.
Thank you all. And yes, I think overwhelmingly the themes that came in advance were people are keen to understand what is different under the new standards as compared to the legacy standards and how to implement those in practice. So we'll get into it. We have a question here, I think for Susan. Before April 1st, I was a professional executor for 2 colleagues who were psychologists who retired before April 1st. I'm not sure what my current responsibilities are. Would you like to speak to that?
Sure, and I flagged that one as well as the succession plan question, but it was before Tigerson spoke to the slide on that. So I think Tigerson has answered that in his slides that an executor remains an option. So you might want to speak to the people for whom you're an executor and ask if they would like you to continue if you're willing. Then that would be a succession plan for your records. So it's not that it's not allowed anymore. It's just not the only requirement. There are other options for succession plans available. So I think that's those 2 that I flagged. Anita, I think Tigerson has answered them already.
Excellent. Both in advance and during the session, we got a question about delegation. So I'll read the specific one, which is that the bylaws seem to be unclear with respect to delegation of psychological services. They state psychologists must not delegate any restricted activities unless supervising a practicum student/resident. It doesn't provide guidance on very common practices in psychology, such as psychometrists, I'm saying that wrong, or school psychologists working under the supervision of licensed psychologists in private practice. This lack of clarity is impacting current practice. Are you able to clarify the nature of restricted activities for psychology and how common and well-established practices such as psychometrists fit into this?
Yeah,
Joanne,
thank you. And yeah, thank you, Anita. Yeah, we do have a delegation that we had a delegation. Poof. Yeah, it is we have a webinar that we had in January specific on delegation. So I would encourage people to look at it, but I will address it in short. So in that webinar, we spoke to how the Act now consider what is delegation versus assignment. The 2 terms have been used quite differently in various professions that we regulate. Delegation is now a legal term that is being used to delegate restricted activity or aspect of practice, who is also now a defined term in the Act. The use of psychometrician to deliver tests as part of psychological assessment is considered an assignment. It is not considered a delegation because the psychologist is not asking the psychometrician to go assess the patient. They are asking the psychometrician to complete maybe several, but at least one test, or that is part of the assessment. The psychologist will then use that to actually complete and make conclusion and findings. So we consider these to be assignment, not delegation of restricted activity or aspect of practice. In the webinar, we actually define what is an aspect of practice. We also provide a few examples and also kind of trying to define restricted activity for psychology or related to diagnosing. And so again, it is not something that we anticipate would be delegated to a psychometrician, for example, but we consider this to be high-risk activity that the licensee should perform, and it should not be delegated to someone. So if you have more specific question related to your practice that you're unclear, those are really good questions to send to Tigerson, and he's going to be able to help you and work through that.
Thank you. This is a question about records. Will the Ministry of Education also direct school districts to keep records in alignment with the new record retention period? What happens if school districts don't adapt their practice?
Yes, I think again, Tigerson had a sort of a good slide around the importance of having conversations with, if you are not the record holder, whoever is holding those records on your behalf. So I think the first step would be to check and find out what the school district, how long they're holding them, and explain your obligations around retention and access, and to make sure those align. And if they don't, then having some conversations about, the how to allow you to meet your college standards within that framework.
Moving on to a higher level question. This was submitted in advance. How should we use the new ethics framework? The tenets are laid out, but it's not explained how decisions should be made with them.
Right. Yes. So it is a different level. I think that one of the messages we want to make sure we convey is that, this is a harmonization of the standards. And so it's not intended for that registrants will be, or sorry, licensees will be practicing differently. We don't anticipate, for the most part, other than things like how long you're holding your records, that this is changing psychology practice. Rather, it's moving the standards to, the minimum enforceable expectation, so that it's written at a less prescriptive level for the most part compared to the code of conduct that you're used to with the legacy college. And so you are welcome to continue to, refer to the legacy code if there's more detail there that you find helpful. I suspect that if there's something that the standards should speak to sort of expanding on the ethical principles. If you think that there are gaps available, again, you can always reach out to Tigerson, but I would say that it should sit nicely alongside, for example, your Canadian Code of Ethics. Like when I read those two things together, they're not in conflict. One is just written with much more prescriptive detail. And so the other thing that's in the works is that we are developing a guideline to go along with each standard, and including the Code of Ethics. And so you can look forward to, in future, there being a resource document that will assist in meeting the code, that will likely contain some more detail, similar to what you're used to in the legacy code.
Thanks, Susan. We received a couple of questions about title. So these are two that I'm combining. The first part is clarification on use of title. Is abbreviation of psychologist accepted, such as psych, along with other concerns previously raised? I don't know what that means. The second part of that is, what is going to happen with the protected use of the term psychotherapy?
Okay, I can take a first stab, and then you guys can add anything after if you want. So protected title lives in the regulation. So in our case, the health and care profession regulation. There are parts for each of the 9 designated profession that we regulate, and then you'll find the title that is protected. So as of April 1st, the regulation did not include for any of the profession that, not just our college, any profession does not have abbreviation that is protected in regulation. The college could choose to prescribe the use of abbreviation, but it could not protect abbreviation because the protection lives in the regulation. So even if the college says would prescribe the use of abbreviation by licensee, they would not be protected. We choose not to prescribe abbreviation in bylaw at this time. The position of the college is that as much as possible, what we recommend is the use of title. That is what is clear to the public in terms of you being a licensee. We definitely know that in every profession, the use of abbreviation is a thing because, of course, title are not always short, like psychologists, physical therapists, like those are not short words. And it's just part of the evolution of the profession where sometimes it's just very much known that occupational therapist, it's an OT and everyone knows what that is. We're not telling folks that you cannot use abbreviation. We're just not prescribing the abbreviation that you must use in your practice. We encourage and recommend that people consider when it's appropriate to use abbreviation. Your patient, your different client might not always know what abbreviation means. And so making sure that you use it with people that will be able to understand what those mean and that they're clear and that they're in line with our general marketing standard, I guess. For psychotherapy, that is not currently regulated in British Columbia, but will be in November 2027. The protected title will also be in regulation, that is government that makes the regulation, makes these decisions. What was published last summer was that the title was going to be psychotherapist. That was going to be the protected title for this profession. Psychotherapy in itself wouldn't be a protected term. It speaks to what the scope of practice for that profession is. So I don't know if that was the question, but if that's not really what people wanted to hear about, they can submit another question. But yeah, Susan or Tigerson, I don't know if there's anything else you want to add on that, but okay.
No, the only thing it made me think in connection with the standards is around our sort of communication standards and our obligations to communicate in a way that wouldn't be misleading to the public. So I think we just want to think about sort of to what Joanie was saying is, would the public understand if they saw an abbreviation, whether that meant you were a psychologist versus a psychotherapist or otherwise. So just kind of keeping in mind who your audience is. Yeah.
Okay, we have a question here asking if we could please clarify if provisional psychologists are responsible for maintaining / securing client records, or whether the responsibility lies with the supervising psychologist. For instance, as a provisional psychologist, am I responsible for retaining the records for 16 years, or would this be my supervisor's responsibility?
So, Joanie, do you want me to?
Well, go, and if I want to add.
Yeah. So what I'm thinking is, like, as a provisional licensee, you're bound to meet the standards. So I think that in the absence of an agreement with the supervisor, that the supervisor, for whatever reason, has agreed to take that on, we're regulated individually. So I think if it was a record of that provisional licensee, the college would be expecting that that provisional licensee is accountable for ensuring the retention of that record. That doesn't stop a scenario where that provisional licensee has made an arrangement with the supervisor to hold records. So I think both of those things could happen, but ultimately, I think the provisional registrant is holding the accountability for ensuring that they are retained for the duration of the retention period. Joanie, is that your interpretation?
I mean, a provisional licensee is a licensee of the college, so they're accountable to all of the standard that includes. So yeah, your answer covered what, unless there's a specific agreement that somebody would be accountable to keep the record, it's each licensee is accountable to their practice and meeting the standard. Provisional just means that they haven't met all of the requirement to be a full licensee. Yeah.
That's a good, actually, clarification that while they haven't fully met all the requirements to be a full licensee, they are expected to fully meet all of the requirements set out in the standards and bylaws. So that's a good clarification. Thanks.
Yeah, and one of the things that we may want to also keep in mind is whose patients are they? Do they belong to the professional licensee, or do they belong to your supervisors? So that can also determine who's going to keep the records too.
Yeah, good point.
In advance, we did receive a question about racism and determining the bar for mandatory reporting of racism. Is that something that you would be able to speak to further?
Yes, I might want to go back to it because I like to read the specific section of the Act when I answer a question. I can speak to discrimination first. I'd like to, because that is more close to my memory. The duty to report discrimination is a duty that speaks to if you have witnessed someone having an actual impact, because discrimination can be a word that is not necessarily well understood. It is defined. There is a piece of legislation on this that kind of says what discrimination is. We actually also hosted a webinar on this in February that was really great, where we had both a lawyer and an Indigenous person speaking to both of these topics. But it is an important distinction that the duty to report generally speaks to reasonable grounds. And also meeting the threshold of what discrimination is defined in legislation. And then, well, I could go back to this question once I've looked more closely to, unless you feel comfortable answering that, Susan, if you have it closer.
Yeah, no, I've got my big bound copy of the HPOA here, so I've got it opened up at section 86 and 84. But it's exactly what you said around reasonable grounds and the wording around discrimination. And so I think when we think about duty to report, it might be helpful to read those couple of sections because it does talk about the reasonable grounds, in particular, some of the other duties to report around their continued practice of the health profession posing a significant risk of harm to the public. So those are some of the bars around duties to report that are set out in section 84, 85, 86 of the Health Professions and Occupations Act.
Thank you. We also have a question about the difference between duty to report a client who is imminently dangerous to themselves or others versus reporting a licensee whose practice is a risk to the public, but they are our client. Is the standard of confidentiality predominant, or do we have to report our client if they're not meeting professional standards, like, say, maintaining records according to the HPOA?
Okay, I'm happy to take up the first round and then maybe pass over to the two of you. So what that makes me think about, again, is that bar. So the question around if they're not meeting records standards, I think the sort of provisions that we're thinking about is the other licensee is not fit to practice, and the continued practice of the designated health profession presents a significant risk of harm to the public. So, the records example, in some cases, you might decide that does not meet the bar, depending on the context. However, depending, and Tigerson could paint a scenario where that risk would be really high if that continued in terms of the danger to the public, what that risk presents. So this is one of those things that is it's very context specific. And so the ongoing practice, that's a decision that is uncomfortable. It happens across all of our professions. We have that duty to report from our own profession or another profession. It's something you could potentially call and have a conversation with Tigerson if you wanted to have a bit more specifics around a scenario. The other piece of that question was, do we have an obligation if they're a patient? So two things about that. I suspect that when you get consent, it might be part of that consent conversation that if you disclose information to me, that gives me reasonable ground to believe that your continuation in your health profession would pose a significant risk of harm to the patient, I will be obligated. I have a duty to report that. So that's probably part of your consent conversation, because the Act doesn't parse that out. So it puts a duty on health professionals with respect to where there's significant risk of harm to the public of ongoing practice. And so I think a couple of things. One, I'm not sure whether psychologists have this. Many health professionals, when we assume, and I'm a physiotherapist, so the liability insurance that I carry entitles me to have some free legal support. And so that would be a question where I would reach out to my legal advice at my malpractice insurer if I wanted to talk about a specific scenario like that, where I wasn't sure where those two things intersected. But the other thing is we usually look at it in a hierarchy, that the HPOA is more enforceable. I think, Joanie, that's fair to say, right, than standards. So that the duty to report in the HPOA sort of trumps what is written in standards. So my sort of thought about, because I think maybe it's easier to think about if we think about it in the context of if you had a concern that your patient, we have a duty to report sexual misconduct, sexual abuse. If you thought your patient, who was a health professional, had engaged in sexual misconduct or abuse of a minor, I think we would all think that was pretty clear that we had an obligation to report to the regulator, even though we have that therapeutic relationship with that person. So these are significant risk of harm to the public. And so, as I say, context matters, and you might want to have a conversation if you do have access to legal counsel. But the way the Act is written, it doesn't give a caveat to say that you are exempt if they're your patient. And in particular, there's wording that requires, like, a physician who admits a patient who is a regulated health professional who would not be fit to practice, they have a duty to report to the college. So I think there is precedent in that context.
Yeah, maybe I'll just add, because we also had a question that's chat that spoke to non-licensees. So I think the Act is pretty clear when it comes to any licensee. So if the person practice a health profession, you have a duty to report in that case. If it is a non-licensee that disclose information that leads you to think that there is an imminent risk of safety to themselves or others, and you practice in private practice, there is a section in PIPA where you can disclose personal information without consent. But it is in the case of where there is imminent danger to themselves or other. So I think this used to be labeled quite clearly in the former code of conduct. That still kind of is something that you by statute are allowed to do. And I think that's why it wasn't necessarily carried over in that level. It's because it was already covered in other legislation.
Yeah, so Section 18 of PIPA covers that quite clearly, and that's in alignment with your previous code. So it's already covered in that act. Yeah.
Okay, we may have time to get a couple more questions in. The next one is about school psychology. Can you clarify if a school psychologist can perform school psychology practices, for example, psychoeducational assessments for the purpose of educational planning, but in a private setting outside of the school/institution?
Okay, yeah, I know we definitely had received lots of questions about this, lots of questions about independent practice outside of the school system by school psychologists. It is something that's been on our radar for quite a while. It comes in regularly in practice support question. Like with looking at how the regulation is worded as of April 1st, it is something that we're hoping to provide further communication and clarification once we've had the chance to do further legal analysis and actually get information on from the profession at that effect. So at this time, I couldn't provide a further update except that people can continue to practice as they were prior to April 1st, and that further communication on this will be done once we've had a chance to complete that work. The priority was, of course, to get through the finish line. That was April 1st. We had a lot of work that was needed in order to be ready, but we know this is a topic of high interest. We've had a couple of conversations with the association on this. We've also had conversation with ministry about this, and we will provide clear information once we've been able to complete that work.
Thank you. We have another records question. For records ready to be destroyed in 2026, according to legacy codes of 7 years minimum plus year of majority, are these records now needing to be adjusted to 16 years?
So that'll depend on whether they exhausted the retention period before April 1, in which case your legacy code applies. But if they were midstream in their retention period, then at April 1, then the 16-year retention applies. So if you exhausted your 7-year retention period on March 30th for that record, it can be destroyed. But if it was midstream and April 1st hit, then that record falls under the 16 years.
Okay, and looking at the time, we're just about done. Susan, I think you wanted to speak a little bit about the practice support service.
Yeah, I just wanted to say, like, we're really thrilled about the engagement, and it's good to see the number of questions, but we want to make sure that everyone's aware that Tigerson, as a psychologist and practice advisor, is available for your questions that are more, perhaps some specific to your own practice at practice support at chcpbc.org. And as Joanie said, these questions give us a really good idea of where you want more information, and we will hang on to them and do our best to answer them potentially in further communications. And I'll hand it over to Joanie.
Yeah, thank you. I was just looking at the list of questions that was left in the chat that we weren't able to address. I think I would really encourage people. We've published a few things on records in the newsletter recently. We've also published a post on title, the use of the title doctor, also the use of licensed versus registered. So I know there's so much information that comes out of the college and probably many other organizations in your email inbox, but it is a good source for you to look at in order sometimes to have your question answered. We will also be looking at that list and see how we can maybe address a few more, like especially if we know these are common themes. But really, thank you for taking some time to be here today. We really appreciated the engagement, and stay tuned for potentially more opportunities to engage in the fall.